Comfort Emmanson, who is accused of assaulting staff of Ibom Air, has now been released from Kirikiri Correctional Center. Magistrate Olanrewaju Salami of the Samonilori Courthouse, Ogba, struck out the 5-count charge in a brief hearing earlier today.
At the resumed hearing, Police Prosecutor Olubumi Adeitan told the court of the decision of the Commissioner of Police, Lagos Airport Command, to withdraw the charges unconditionally in line with Section 72(1) of the Administration of Criminal Justice Laws of Lagos State 2015. She also presented a letter from the police boss dated August 13, 2025, which the court admitted as evidence. The police inspector added that this development arose due to more facts made available to the police after Comfort Emmanson's arraignment on Monday. Lead Defense Counsel Adam Satakpa said he was aware of the new decision and didn't object to the application of the prosecution. In his ruling, the magistrate expressed satisfaction with the positions of both counsel and accordingly struck out the charge. He also advised the 26-year-old to always display wisdom in future, no matter the provocation, adding that she played a role in some regards in the controversy.
The case has been officially withdrawn before the magistrate, and then Comfort has been discharged. So that was what transpired today. The prosecutor came, brought an application for withdrawal from the Commissioner of Police, Ikeja, and presented it to the magistrate, and then our application was that we had no objection, so that's officially all for the case for now. Since a viral speech has been issued by the Federal Minister of Aviation, my learned senior Festus Keyamo, so I think the matter should be laid to rest. So it's an unconditional withdrawal. So, and then Comfort has been discharged.
Past few days has been a flurry of unexpected activities, to say the least, for Comfort Emmanson, which have also been closely followed by the public. From what was supposed to be a regular flight from Akwa Ibom State to Lagos State, she got into a fight on that trip and ended up here in court, where she was arraigned on Monday and pleaded not guilty to a 5-count charge of assault and other alleged offenses. She was remanded at the Kirikiri Correctional Facility pending the fulfillment of her bail conditions until October the 6th. But thanks to the intervention of the federal government, she's now free.
And in a related development, the federal government has reduced flight ban imposed on Fuji musician Wasiu Ayinde to 1 month. The Minister of Aviation and Aerospace Development, Festus Keyamo, says the Nigerian Civil Aviation Authority also plans to engage the musician as an ambassador for airport security protocol. Mr. Keyamo mentioned that the retreat will be held next week to restrain aviation security personnel, retrain their personnel on managing disruptive passengers and de-escalating tense situations. The minister stressed that the clemencies were granted purely on compassionate grounds. Let's bring in lawyer Olayinka Ola Daniels for more perspectives to these developments. Thank you for joining us, Mr. Daniels. From a legal perspective, does this really end the matter completely, or are there still grounds for the passenger to sue the airline for damages, especially considering the viral video of our ordeal?
Well, good evening, Nifemi, good evening, viewers. Well, going by the law, what has happened, I think that Mr. Keyamo, the minister understands that some things should have been done before others. And that was the reason why he intervened in this matter. And he had to, make sure that everybody come to, a round table to see how we can do this without the route we went through. Unfortunately, well, I don't want to use the accused because the matter has been jettisoned, it's been retracted in court, it's been withdrawn. So I would say the passengers can actually, particularly the lady, it can actually go ahead to court to sue the airline. The lady has a right to his personal dignity under Section 34 that was violated. Now, we're talking about Section 35, the Chapter 4 of the 1999 Constitution. Section 35, as amended, also gave liberty, freedom for everyone to move anywhere. But sanctions were made without adequate investigation. On both sides, on the Kwam, on the lady, actions were made. And what we know, according to procedures and to law, you need to investigate first, so that justice will not just be carried out.
Indeed.
It will be seen that justice has been done. So when you rush things, this is what happened at the end. When you have not investigated, because one, is there fair hearing in this whole saga? We only heard about the airline side of the story, but no fair hearing to the lady. Now the videos are coming out, the witnesses are coming out, and they are stating the facts that happened, which they should have done initially. The AON, the NCAA, all of them, they were too hasty in arraigning this lady. And that is not good for our democracy. It is not good for the rule of law.
Absolutely. And that's also the position of the NBA. We spoke with the president on the news last night, who mentioned that the AON ended up being the judge and jury in its case. But this case, we've seen it move drastically from a life ban to criminal charges and now to complete freedom in just a few days. There are questions as to what this says about how aviation disputes are handled in Nigeria and whether or not due process was followed. But given the public nature of this case, Mr. Daniels, what legal lessons should we learn, especially for both passengers and airlines, to prevent similar situations from escalating to this level again?
First of all, if you subject yourself to use any airline, there are rules that goes with it. For instance, both sides. If the air hostesses have said, do this, just follow the instructions, just obey. It's as simple as that. If both of them had obeyed, I don't think we will be here. So, to avoid litigation and all this, and to also to work with international standard on aviation, so that we'll not be making a laughing stock in the world. Some of these things could have been avoided if they are listening to all the hostesses. Then on the other hand, even if anyone, assuming without conceding, if anyone had erred in his own duty, I'm talking about the passenger now, it is also not the duty for the staff to treat the matter the way they have done. So there are better ways in which this matter could be treated. So, and that is what, because it's going to be a test to the rule of law and a test to our litigation in the country, and not just making us a laughing stock. Now you rush it, you went to court, then you came back to say you want to withdraw the matter, and meanwhile, this other lady has spent time in Kirikiri. Kirikiri is not, you see, we have said this particularly in our legal industry, that there are some cases that need to give holistic view to before they are being remanded in prison custody. There is no reason why the magistrate cannot remand that lady to the police, whether police in care of the police custody, pending the time of investigation. If police has erred by not investigating matter before prosecuting someone, then the court should have looked at the matter holistically. If it's for instance, armed robbery, murder, and all that, yes, you can remand them to prison immediately. But in these circumstances, so we really need to see how we can have a reform, even in our judiciary and when court, because some of us, as we have said this over time and time, to say, look, it is not everything that is brought to your desk, to your table as a court, that you just, the first thing you want to do is to remand them in prison custody. So in this case, we need to really look at our legal, system and see how we can reform this part of it. And it's not everybody that necessarily need not be in Kirikiri that is sent to Kirikiri. That one day, the same day, that day means a lot. To be in Kirikiri, anything could have happened.
A good place to leave it. We have completely run out of time, Mr. Daniels. But I'm hoping that in the coming days, we can tell whether stakeholders have really learned their lessons and also put in action the reforms needed going forward. Legal practitioner Ola Daniels, thank you so much for talking to us.